Vakratunda Mahakaya Koti Surya Samaprabha Nirvignam Kuru Me Deva Sarva Karyeshu Sarvada. My humble salutations and greetings to you all on this auspicious day of Ganesh Chaturthi. I, Ajit Gigi, student at University Law College and Department of Studies in Law, Bangalore University, consider it my proud privilege to be the master of ceremony for today's special lecture. On behalf of our institution, I would like to extend festival greetings to you and your family. Lord Ganesha is known as Vigna Vinashaka, annihilator of obstacles. In these tough times, I hope the Lord annihilates the pandemic. Lord Vinayaka also symbolizes knowledge and wisdom. And today, on the festival day, we have virtually gathered here to learn and gain knowledge, which is a true form of worship and tribute that we all can offer to Lord Ganesha. Today, we have with us a great inspiring personality, Shri Vikramjith Banerjee, Additional Solicitor General of India, who will be delivering lecture on the topic, Reading the Constitution Culturally. I now request our beloved Professor, Dr. Suresh V. Nadagaudar, Honorable Principal, University Law College, Bangalore University, to welcome our special guest and the virtual gathering. Over to you, sir.
Thank you, Ajit. Good afternoon, everyone. At the outset, I wish you all a happy Ganesh Chaturthi. May Lord Ganesha bless all of us with wisdom, knowledge, happiness, and joy. Our esteemed guest speaker, Shri Vikramjith Banerjee, our Honorable Vice Chancellor, Bangalore University, who will be shortly joining us in the course of lecture. Our esteemed colleagues, invitees, President and members of the Alumni Association, dear students, research scholars. We are really happy and privileged to have today Shri Vikramjith Banerjee, Senior Advocate, Supreme Court, and Additional Solicitor General of India, who has excellent academic career and rich experience of practicing at High Courts as well as at the Supreme Court. He is a proud alumni of our National Law School of India University, Bangalore. I am grateful to you, sir, for accepting our invitation and being with us today to address all of us. I, on behalf of Bangalore University and University Law College and all the students, extend you a very warm and cordial welcome to this special lecture session. Our Honorable Vice Chancellor has already informed that we'll be joining with us. He is an eminent academician and administrator, and he is a source of inspiration for organization of series of these activities in our college as well as in the university. I extend him also a welcome to this program in his absence. We have our senior colleagues, Dr. V. Sudesh, former principal, Dr. N. Dashrath, Chairman and Dean Faculty of Law, and all our esteemed colleagues. I extend all of them a warm welcome to this program. And we have a special guest here, Professor T. Ramakrishna, Professor of National Law School. Mr. Vikramjith Banerjee might be his student. And I extend you a very warm welcome to this program, sir. And I also welcome the President and alumni members of our University Law College Alumni Association and all the invitees and all our dear students and research scholars. I would like to make a special welcome to all the applicants for seeking admission to our prestigious University Law College who are aspiring to join us as we are planning to hold the admission process online. We thought that we should invite them also just to make them understand about the use of Zoom app and all that. So I also extend them all a very warm welcome to this program. Thank you all.
Thank you, sir. On behalf of organizing committee, I welcome you too. Before we get started, if participants have any questions on the lecture, please type them in the chat box and send it to co-host Satyajit MS of the event. And YouTube viewers can post their questions in the comment section below. We will take them up after the lecture during the question and answer segment. As we all know, the topic for today's lecture is reading the Constitution culturally. Now, I take this proud privilege to introduce the esteemed dignitary, for today's lecture, Shri Vikramjith Banerjee. Vikramjith Banerjee is a senior advocate at Supreme Court of India, New Delhi, and incumbent Additional Solicitor General, Government of India. He graduated from the National Law School of India, University, Bengaluru in 1997 and completed his LLM from the University of Leicester in 2000. He was also a faculty at the West Bengal National University of Juridical Science. Vikramjith Banerjee was appointed as the Advocate General, Nagaland in 2015. He was designated as Senior Advocate by the Guwahati High Court in 2016. Vikramjith Banerjee was appointed as the Additional Solicitor General in 2018. He was the youngest in the batch of 3 new ASGs who were appointed. He is also the first NLSIU graduate to hold this constitutional law office. So, we are extremely honored and are eagerly waiting to listen to your lecture. Over to you, sir.
Thank you, Professor Nadagowda.
Thank you, sir.
For being so kind and for inviting me to this lecture. I understand it's a huge honor. Bangalore Bangalore is my favorite city in the world, and I tell people that it has great memories, and it's the people and the place that it's. I don't think I'll in my life I'll be ever be able to forget, or for that matter, ever be able to repay. I owe so much to Bangalore. Second, thank you, Ajit, for that wonderful introduction. But I don't know whether I deserve it, and I don't think I deserve the huge amount of praise which I've got. But thank you nonetheless. The inspiration of the talk, which I'm going to sort of present, presentation which I'm going to make, comes from a discussion which is now going on in legal academic circles very, very frequently. Is that what is the nature of the constitutional state that we have? As in, what is the nature? As in, how should we construe the Constitution? There is a line of judgment, the Supreme Court, and I won't go into detail on that because that's not relevant for what I'm going to say. There is a line of judgments which says that the Constitution is transformative. That is, the day it comes, it's ground zero. When the Constitution is formulated, it is enacted, that's where history of India actually starts. And everything which happens subsequently has to be tested on the Constitution. In the famous Sabarimala judgment, which is the apogee of this line of thought, there is also a dissent by Justice Malhotra, and this is where I take off from, and I'm saying this as a reference point to what I'm going to focus and expand on. Justice Malhotra says that there are two ways to look at the Constitution. One is to look at it as a transformative Constitution, as a Constitution which transforms people. And the other is to look at the Constitution as a cultural continuum, as a cultural constitutionalism. Now, Justice Malhotra mentions that in the dissent. Now, that's the dichotomy which we are largely facing in constitutional law today. Something which we can see happening every day, something which faces us in all constitutional issues, as to whether we should take the Constitution as day zero, or should we read the Constitution as a continuum over a large number of sequential developments. What difference does it make? The first question is, what difference does it make? If it's read as a transformative constitution or it's read as a cultural constitution, what difference does it make? To me, it makes a huge substantial difference. It's like, it is because once you read it as a transformative constitution, once you read the document, for the one I'm using a legal term, dehorse, or without the background of the culture, of the developments, of the history which goes behind making of the Constitution, then the Constitution itself becomes in some ways hostage to those who are going to interpret the Constitution. And that becomes a problem. Then it becomes hostage to those people who hold themselves out as constitutional experts, and which creates its own problems. It is my view that if you have to read the Constitution is not alone. It has to be read in context. It has to be read as part of the historical development which happened in India. It has to be read culturally. It has to be read in consonance with the culture of the country which we live in. That being said, the next point is, and this is also needs stressing, that the logic of something like transformative constitution, sort of, which believes that a day zero in the creation of the Indian nation, in the creation of the Indian state, is very unusual in the way Indians see history. Because all of us know that in the West, or even in Islamic law, the formulation of history starts before and after. In the West, it starts with, as they say, BC, before Christ, and AD, that is Anno Domini, in the year of our Lord. So it's actually, there is a transformative event, which is a break with the past. Similarly, with Islamic law and thinking, there is the concept of Jahiliyyah, that whatever, once the word of God has come, anything before that is irrelevant. Anything before that is not to be considered. In India, in Indic civilization, Indian thought, that is not how we formulate our own history of any document. We treat our history as itihasa, which we know. Itihasa is something which where past is with us, it lives with us, it is within us, and we are part of the past. We interpret the past continuously, and we add to the past. We interpret the past in terms of the present. We change our history to what, so that we can draw lessons for the present from it. So our conception of history is extremely different from that of the West. And as a result, I do not think this entire conception of transformative constitution is in any way in consonance with Indian thinking of how we think about the past, how we think about our laws, the conception which we have of our society, and the conception we have of our past as well as of our future. Now, the next question is, which obviously will arise after this, is, when I talk about the constitution, what is the history of the constitution that we discuss about? Because people, those who propagate transformative constitution, almost try to make out as if the constitution was given as a complete document, like a religious text. It was given, it was handed over, and from now onwards, everything which you had before that is irrelevant, and from everything has to be tested. What happens in the future has to be tested on this given document. Now the question is this true? Is it true? And that's something which we have to sort of value and sort of weigh and decide. Now I will break the history of the formation of the document, of what we consider, what we say as the Constitution of India, into two parts. First is the development of common law in India, and that's extremely important. Because at the end of the day, the constitution which we have today is a product of the development of common law in this country. The common law, what is the common law in India? You've seen when the British first came into India, they came into these presidency towns, they brought in their law, and some of the most major reforms of Indian law were formulated. We may not agree with it, we may disagree with it, we may have differences with it. I certainly have large differences with the conception which the British brought, which they sort of brought into India, which they brought because they had to govern this country, as simple as that. So they brought in, whether you name it, they brought in the Indian Penal Code, they brought in the Contract Act, They brought in the Indian Evidence Act. They brought in the Criminal Procedure Code. They brought in Civil Procedure Code. They brought in evidence, transfer of property. They basically, in many ways, changed the formulation of law as we know it. It transformed Indian law into common law. Now, this is a radical change, and this is such a radical change that it's almost unthinkable today. It's even more unthinkable, and this is all of us, we know that English wasn't even the official language for a very long period of time, even after the British first came into India. Farsi was, and the entire governance of this country was carried on completely differently from that of common law. And it is exactly in a period of maybe 100 years when this complete changeover happened. And so we cannot sort of disregard this history when we consider the history of our constitution. That is the first part of it. That is contextualizing as to how our constitution, our constitutional values came into effect. Now, what are the values of our constitution? That's important. What is the history of our constitution? When we talk about our constitution, that is the history of common law. But what is the history of the constitution which we see today? How does it function? Where does it come from? And these are things which need to be discussed. These need to be discussed more often, because I think we also, when we were in the National Law School, we treated the Constitution as a fully grown document, as a document which existed by itself. But as we grew older, as all of us study the Constitution more and more, you will realize that the Constitution is a product of a struggle. And I say this all the time, that it's a struggle for people of India to get representative government. It is convenient, and this is a part of history, it is convenient for us to lump everything as a part of the independence movement. But it could also, and it should be seen legally as a movement to get representative forms of government in India, which obviously finally culminates in us being able to rule ourselves. Incidentally, the last sort of government which we had, previously we had the Mughals, before that we had the Afghans, but the last, within that we had the Marathas, but incidentally, the last sort of government which we had were of the British for the last 200 years. So our struggle to get a representative government was against the British. So all the forms of representative government, which the British may have been passed in Britain, there is no doubt about that, but they were in response to the demands which existed on the ground. So the modern state, which is today a product as seen in the Constitution, is a product of a large amount of representation, work, demands which had gone to have a representative democracy, which we see today. So the product of the Constitution, as we see today, was not fully formed. It became a product of a large amount of work which had gone in, not only at the Constituent Assembly, at the Constituent Assembly, because all of us who read the Constitution know that the Constituent Assembly discussed very limited issues. It discussed in great detail fundamental rights. That's what it discussed. It discussed minority rights. It discussed emergency powers. But a large part of the Constitution was taken for granted. And because that Constitution came from 1935 Government of India Act, which itself came from the 1919 Government of India Act, which had a large history. So it had taken all these things into account. Now, let's illustrate it. Let's talk concretely. So the first question is, we talk about our federalism today, the balance of power of the center and the state. We have 3 lists. We are very proud of it. We think that's an ingenious sort of invention which was formulated. All of us know it does. existed in it was first formulated and brought in the Government of India Act 1919. Then we know that the final formulation, which we see today, was formulated in 1935 Act. So it's not a new invention of the 1950 Constitution. It has its back history of going to the Government of India Act of 1919. And this is another question, relevant, and I'll just mark issues and I'll flag issues of what is the history behind all these formulation. Now, the background of all this division of different provinces is because there was continuous tension within the government of different provinces. There was the province of Bombay, there was the province of Calcutta, there was the province of Madras, there were other new provinces which were created, and there were continuous demands of their independent power, of their independent representation against the power of the unified, at that point of time, before 1911 in Calcutta, and then in Delhi, against the central government and the federal government in Delhi. The 1919 Government of India Act, in 1935 Government of India Act, they said India was a federation of states, which we changed to India's union of states in our constitution. But there was this continuous tension, and this tension is not new. This tension has existed from the time of the formulation of the constitutional mechanism, which we need to see as a process. And that's what I'm saying. We need to see it as a process. We cannot say that it came out as a product of the Constitution. It existed much before that. The undercurrents existed much before that. The representations existed much before that. The politics of it existed much before that. The second big issue, which we are all used to, is this entire conception of reservation, of depressed classes. Now, how can we today seriously talk about reservation and depressed classes if we don't discuss, if we don't contextualize it in context of the Pune Pact? How can anyone do that? The politics which went into it, the thinking which went into it, the struggle which went into it, it cannot actually be done. Another example, and this is the entire struggle, depressed classes, the struggle for Dalit rights, the struggle of Babasaheb Ambedkar. This all went into the Pune Pact, which got a reflection into the Constitution. How can anyone disregard protection of minority rights and the intricate protection of right to religion without discussing what happened at the time of partition and the issues which were raised at the time of partition? How can anyone discuss what we have today is joint electorates and very clear mandate for joint electorates, and to say that it was specifically given up because the history of what happened of separate electorates at the time of 1935 Act? There is a lot of discussion today talking about of separate electorates, of protection of minorities. Religious minorities need to be protected. All this had been tried. They have been worked and they didn't succeed. And therefore, the Constitution of India gave up these things. So this entire question needs to be discussed. This entire interpretation of Constitution needs again to be interpreted in terms of these experiments which had happened, which we had discarded, which had failed, which had horrible repercussions for this country. Some were good, of course. The depressed classes provisions were good, were beneficial for this country. The federalism arrangement worked out for this country, but there were provisions, things which didn't work out, which we gave up. Another third issue which really worked out eventually for this country is this methodology of governance, of having a bureaucracy, which is the iron frame of this country. The first public service commission was set up in the Government of India Act 1919. And then it was again, of course, put in place by 1935 Act. We just kept that provision in the Constitution of India. Now, all of us know it's the bureaucracy which is the iron frame of this country. And it's a product of development, of the fact that, there was a struggle of getting represented in the bureaucracy, of Indians getting represented in the bureaucracy, and the importance of bureaucracy, how it ran the Indian state before independence. So that's all runs parallel with our demand for representative governance. So what is the place of bureaucracy? And we know that bureaucracy in India today is extremely important as well. So all these are constitutional arrangements, and this had a huge back history. Coming to the fourth point is representative governance. Now, all of us know this. Representative governance, there is a huge back history of representative governance. The first formulation of representative governance of having a bicameral legislature and political parties goes back to the Government of India Act in 1919. And of course, which then gets encapsulated in the 1935 Act. Government of India Act, it used to be called the Legislative Assembly and used to be called the Council of States in 1919. So we borrowed large, there were politics, there were internal politics, and I don't want to go into the politics of provincial legislatures or national legislatures at that point of time, but I can assure you that if you take out the national legislatures aside, but if you look at the political legislatures, political provincial legislation elections, you would be able to identify the undercurrents and the representations, which still today, and I'm from Bengal, and I can, it's so apparent and so striking that those political undercurrents, those political formations are still relevant. And that is still the basis on which elections are in somehow take place and parties are elected. So those issues still remain. The other issue which all of us are very proud of is having the federal judiciary. The federal judiciary is a product of, there was a large struggle whereby before the federal judiciary, which culminates into the Supreme Court in the Constitution of India happens, there is a huge struggle in India saying that, because Indian cases before that would go to the Privy Council. In Britain, like the rest of the Commonwealth, but there was a huge struggle. I think Muhammad Ali Jinnah was one of the greatest proponents of a federal judiciary. He said, no, Indian cases have to be decided in India. So in 1937, it's actually when, for the first time, you had a federal court which decides Indian disputes in India. So, this also, and all of us know this entire tension which goes on between the high courts and the Supreme Court is again is not new. There were provincial courts, because the formulation of India, the formulation of the judicial structure of India first started with provincial courts, and very, very powerful provincial courts. So as a result, the underlying tension of the hierarchy within judiciary still remains, especially provincial courts and high courts, which were considered to be at the apex of the judicial system in Indian history. I come from Kolkata, and I can assure you that the Calcutta High Court, on very many occasions, thinks that it's a chartered high court. Its history goes back before the formation of the Supreme Court. History goes back, so it has, in many ways, according to it, has predominant rights to decide on the law rather than than of the Supreme Court. It has to give way to the Supreme Court because of the Constitution. But in many ways, the feeling is that we have predominant rights. We're an older court, and so we have, we know much more about a large number of issues, especially on common law. Now, these questions are not new. These questions are fundamental to the governance of India, to the way India is governed, to the way our constitutional framework functions. And these happen on a subsequent, there's a huge historical basis for these developments. And I'm not going into great detail because the talk is just a small talk. It doesn't go into great detail. And I think this is a scope for much larger research and much larger work. But it's extremely important to contextualize it, that these things don't happen in a vacuum. This happens over a period of time, over a period of 100 years of great struggle from 1857. That's how I formulated to 1947, a period of 90 years when this movement of representative democracy, which we see today in 1950, actually takes place. My question is, and this is a question I'll go back and forth on this, is can anybody disregard this history? When you talk about a transformative constitution, can you disregard this history? I don't think it can, because because of a large number of reasons, because it cannot be isolated, it cannot be treated independently. The Constitution cannot be treated isolatedly, cannot be treated independently. Now, the second part of it, and this is something which we also need to discuss, is that our Constitution also needs to be contextualized in the historical development of constitutions in the world. Now, our Constitution exists as part of common law constitutions. And all of us know the common law constitution, there is a large development, and I'll put it sequentially so that it sort of adds to the debate. The first famous common law constitution that we know today is the US Constitution. It talked about federalism, in first place where conception of fundamental rights were first set out. Very controversial at that point of time. I think till 2001, the British Constitution did not have, the British did not have a constitution, did not have a chapter of fundamental rights. And in the end, they could not agree on a fundamental rights. They incorporated the European Charter of Human Rights and said that, this will be our fundamental rights. They could not have a consensus of what would be their fundamental rights, even until 2001. First one was, of course, known to us was the US Constitution in a common law framework. In 1832, I think, which is called the Great Reforms Act, which happens in Britain, is the next big constitutional formulation which happens in Britain, which basically creates the Westminster form of government. Now, the US government is a product of much older times. The US gets independent in 1777. The US Constitution comes in 1976 or thereabouts, and so therefore has a presidential form of government. This is a product of its times, of the king being all powerful, which you see in the president, and king being advised by ministers, which you see the secretaries of state and secretaries of defense, etc., etc., which is completely changed by 1832 by the Great Reforms Act, which makes the king responsible to Parliament, which in Britain creates basically the Westminster form of government, which we are so used to today. And this is another constitutional experiment. So today, when we talk about having in our constitution a Westminster form of government, there is a historical development of that. A historical development which basically goes that past the presidential form of government, which may not work in certain circumstances, you need a system which creates a larger consensus amongst the people. And to that end, people believe that the Westminster form of government was a better form of government. The British, after 50 years, formulated the Great Reforms Act and sort of made, according to it, a further development in common law constitutional making by coming up with this form of government as we see today. The third, another issue, as I discussed, was the list system, sharing powers between provinces. This was formulated at the time of the Canadian Constitution of 1867, because there was this entire continuous pull and push between different provinces of Canada, especially between the French-speaking provinces of Canada and the English-speaking provinces of Canada. So it was decided, how do you share power? The British were in charge. The British were in charge of Canada. They governed North America, north of the United States. And what is the power to be given to the Union? So the list system was formulated. Now, what is the system whereby you can have unimpeded internal trade between provinces? This may seem a small issue to us, but in effect that it's a large, huge issue, because if the provinces were independent, how do you ensure that there is free trade amongst them? This is a product of the Australian Constitution, and it was invented, it was worked out perfectly fine, and it was then incorporated into including our Constitution of India. When we talk about, as I said, first, fundamental rights comes from the American Constitution. Directive principles of state policy comes from the Constitution of the Irish Free State. of 1937, when Ireland becomes independent, it again has this great discussion saying that we want these values to be incorporated into the constitution, just like we had it in India. And the question there arises, what about these values? It happened subsequent to revolution. And you know that Indian nationalists and Irish nationalists had a deep sort of undercurrents amongst themselves, both on the non-violent struggle as well as those who thought violence was a way to get independence. So there was a lot of inflow amongst them. So there was this discussion which happened in Ireland when Ireland becomes free, the Irish Free State in 1937, as what sort of, what happens to these values which we fought for? We fought for a more equal society, we fought for it. So the answer then was that why don't you create a separate chapter for them, which will not be legally implementable, but which you can judge the government on those values. Directive principle state policy was formulated. We incorporated that in our constitution. How can we today say that the constitution came out fully formed? It did not come out fully formed. It came a product of various different influences, huge amounts of history, both in terms of common law, both in terms about the Indian struggle for having a representative democracy. And it has to be, and the reason I say this is because none of the provisions in the constitution we see today can be interpreted out of context of the history in which it developed. And it's extremely important because there is an attempt nowadays increasingly, especially on questions on reservation, on questions of equality, on questions of religion, on questions of minority rights, to interpret the constitution completely independent of the developments and the compromises which went into formulating what would be the final arrangement which is incorporated in the constitution. Now, all of us know the debate as to Hindi as an official language. Now, that was hugely debated and a compromise was worked out. The wordings of the article absolutely encapsulate the compromise. And there are so many issues. There are controversial issues, and most of the controversial issues were a product of compromises which were incorporated in the constitution. Today, when you talk about a transformative constitution, you decontextualize the history in which these compromises happened. Now the third point is, how do I look at the constitution? I not only look at, it has to be read in terms of history. I have a take on the constitution. And the first time I wrote this take, and I was at the National Law School, I was in second year, and I wrote this take. According to me, the constitution as we see it today, how do I interpret it? I see this constitution as a dharmic document, and I've always said this. And I think the first time I wrote it was part of as a student advocate, which is the legal journal of the National Law School. Because what is the basic? What is the basis of this formation of the constitution? I think all of us who look at the constitution, nowadays increasingly it's equality, etc., which is stressed. But the basic quality, and that is social justice, social, economic, and political. We the people formulate a government on justice, social, economic, and political. And people tend to focus on economics. People tend to focus on politics. People tend to focus on social justice, economic justice, political justice. But we, at the formation of the constitution, we did not formulate it in terms of equality. We could have, like the Americans did, equality, social, to create an equal society, equal political society. We concentrated on the word justice. And justice is the basis of the Indian state. And the shorthand, all of us know that you can't have a translation of the word dharma. You don't have that. It's not possible in Sanskrit or in Prakrit to translate outside any Indian language to translate the words dharma. But if you had to translate the concept of dharma in terms of constitutional jurisprudence, the closest you have to an interpretation is the concept of justice. And it is understood that the conception of justice is the basis of the Indian Constitution. In many ways, you would say that it's dharma. Now, whenever the Indian Constitution applies to the Indian state and governs day to day, it comes up with these inherent challenges which arise from Indian society. And I think today the Constitution, the way it's also been interpreted effectively, and I'm saying this effectively by the Supreme Court, and you take away the logic, the argument, the language, because the Indian Supreme Court has been very afraid of relying too much on these conceptions of for that matter, of dharma, because in its own formulation, its own thinking, it thinks that these are linked to certain religious values. They may be, but I disagree with it, because these are absolutely Indic or Bharatiya values. They are deep values which cut across religions, cut across faiths, cut across different conceptions of the world. These are fundamental values to governance of this country, dharma being one, of duty, obligation, justice. And they have largely, and I'll take you through, I have examples of how the Constitution has been interpreted, which makes it in consonance with this cultural, dharmic interpretation. Though the court, for its own, to sort of protect its own conception of what it views the world, tends to isolate itself, tends to separate itself, at least in its writing, in its literature, in its words, in rhetoric, from ever touching this conception of dharma in any great detail. First is the example of secularism. What is secularism? Secularism, according to the court, and that's the clear shorthand example, according to the court, is Sarva Dharma Samabhav. Sarva Dharma Samabhav, it comes from the Ekam Sat Vipravahuda Vadanti. That continuously, that's repeated over and over again. All of us know that comes directly from the Upanishad. It is because it is a dharmic value. It is the way in which we treat different faiths. It is not, secularism is not about a Chinese wall which exists in America, or a laissez-faire which exists in France. This is our values, our system, how we interpret our constitutional values. Second is this conception of for socialism. We've always believed that socialism is not socialism in stricto sensu of the European term. Socialism is something which is akin to Sarvodaya, which is an Indic term, which is a term which comes from absolutely Indic culture, which again has its own values. The court over and over again says that it's a mix of Gandhiism. The reason why it uses the shorthand for Gandhi is because it can't say that it goes back to strong Indian values. Because as we all know, even in terms of interpreting the Constitution, because Mahatma Gandhi is typified Indian values, Indian civilizational values so much that a shorthand for talking about Indian civilizational values is always referring back to Mahatma Gandhi, as if Mahatma Gandhi came in a vacuum, which he didn't. He relied on a lot of Indic civilizational terms and conceptions to formulate his form of governance as we know it. Now, the other conception, so let's talk about fundamental rights. And what sort of fundamental rights do we have today? We have limited fundamental rights. We have limited freedom of speech. We could have given an unlimited freedom, but that is not close to our culture. We've always given limited freedom. Historically, we've given limited freedom because our conception of freedom is different from that of America. Our conception of freedom, historically, culturally, civilizationally, is it does not give you a right to hurt others. We have a freedom, but it doesn't give you a right to hurt others. We have the conception of equality. Now, treating equals equally is something which is extremely, and unequals unequally is something which is very nuanced and it's very crucial to us. When we sort of have this very nuanced conception of jati and caste being class, which the Supreme Court has come up with, this could only happen in India because we believe that jati is a conception, is a part of equality, and there should be an accommodation of within equality, the conception of jati. Now, this is uniquely Indian, because if you addressed it in Western terms, you would just say that it is caste. Caste is not relevant. It would be just class. And class has nothing to do with jati. But the fact that Indian Supreme Court was dragged into in Indra Sawhney to address this question and say that effectively equality means that it has to be jati based, shows that the fact that it is based on Indic values and civilizational values and cultural values of the country. The other is the conception of right to life. Supreme Court in Maneka Gandhi and so many other courts have expanded the right to life tremendously. So it's not only about being arrested, it is across the board right to lead a full life. This is completely very Indic, civilizational in its respect, that life encapsulates everything. Life is not limited, life encapsulates everything. The other is the right of religious groups, certain religious groups to control their own affairs, to run their own affairs, to run it in terms of what they think fit. This is unique. In rest of the world, there are ways how state deals with religion, but I don't think there is any provision which, according to my study, which parallels Article 26 in our Constitution, which gives even small religious groups within religions to operate their faith, their belief in their faith in terms of themselves. And this only happens because we have a constitution which is a product of our own culture. I can go through a number of examples. I think the last one, and I'll finish off this chapter, is Article 32. The court has interpreted Article 32 to even include letter petitions. Now, there is no Supreme Court in the world which ever would do something like this. This is because, again, we believe that you could approach the king, the people should be able to approach the king, the dispensers of justice directly without any middleman. That has been our formulation of justice. You see it today, it has always existed, it has civilizationally existed. And that is how we finally formulated, the Supreme Court has finally formulated Article 32. The question which, you can say that the question which therefore arises is, why doesn't the Supreme Court refer to these values? Why doesn't it refer to these values? I have no answer. One of the reasons is possibly because the Supreme Court is of the view that it would be perceived as not being liberal. If you look at DPSPs, for example, there are a large number of provisions, and I said a shorthand for referring to Indian cultural values in the provision is to refer to them not as Indian values, but to refer to them as Gandhian values. So whenever you talk about protection of the cow, you say, oh no, they are Gandhian values. When you talk about of a large number of village panchayats, then you say no, that's Gandhian values. When you talk about protection of cottage industries of Swadeshi, then you talk, no, they are Gandhian values. They're not Gandhian values because they are in effect, yes, Mahatma Gandhi did speak about it, but they were civilizational values and they are incorporated into the directive principle of state policy. Yes, that's a part of directive principle of state policy. There are also, if you read the fundamental duties which every citizen is to follow, and again, the conception of fundamental duty is an extremely intrinsically Indian thing, which says citizens have a duty to the state. Otherwise, as we all know, in American governance, citizens have rights, citizens don't have duties. Though it may have been borrowed from socialist thinking at that point of time when it was brought into the Constitution, it's also deeply influenced by Indian conceptions. One of the shorthand it uses saying that you follow the noble ideals of the Indian freedom struggle, which is a shorthand for Indic values, because again, there is this dichotomy which is continuously followed. Now, in conclusion, how would I want an interpretation? What would be, how would I sort of formulate my interpretation of the Constitution? What are its objectives? I would only put it this way, that Indian constitutional law and an Indic constitutional law works on two principles of dharma and artha. The ultimate objective is to have Ramrajya, to have an ultimate objective, to have a governance which balances dharma and artha. And we have borrowed deeply from the well springs of dharma, as I spoke to you about, as well as the conceptions of artha. From when we talk about dharma, we have relied on civilizationals, on the examples of effect of the way the world is governed, as I gave you large examples of secularism, etc., etc. And on artha, we have, on the issue of artha, we have on a lot of occasions referred back to the great Mauryan state, which was the basis on which Artha Shastra was written. When we talk about the bureaucracy, which we talk about of treating judiciary as the most important form of a very important and crucial form of governance. So in many ways, we have formulated, the constitution is a balance of these two impulses of both dharma, which we want to promote, to create an ideal state in the form of Ramrajya. And on the other hand, we have believed that the means to achieve that is artha. And artha is the best sort of our universal state. The best formulation of our universal state was the Mauryan state. So we borrowed the Sarnath pillar from the emblem of the Indian state, the Dharma Chakra also in the Indian flag from the Mauryan state. So I think the ideal balance which we want is to move towards a dharmic state, but balanced in some ways by the arthic compulsions of our civilizational state as we see today. In conclusion, and this is in conclusion, I would only like to say this, that there is a lot of talk. There is a lot of talk of treating the constitution independent of the culture and civilization of the people. There is not enough discussion in contextualizing this constitution. It is time that we start discussing these issues, because any constitution cannot be interpreted out of the context in which it exists. Thank you.
Thank you, sir. That was truly informative and enlightening lecture.
Thank you very much, sir, for your very informative and thought-provoking lecture. And I thank on behalf of Bangalore University and University Law College. And our Honorable Vice Chancellor, Professor K.R. Venugopal, has joined us just now. And I request sir to kindly give his remarks. And sir, we have Shri Vikramjith Banerjee. He is a senior advocate at Supreme Court and additional Solicitor General of India. He is the today's guest speaker.
So thank you very much, Suresh Nadgodar. And sir, Vikramjith Banerjee, we are very grateful to you for delivering this wonderful lecture. It has been really enlightening. I was there for the last 5 minutes. I was listening to you, but you know, I am not a subject expert in telling how to read Constitution culturally. But one thing I have always seen, that everybody should read Constitution from cultural point of view. And because we have to, the fundamental purpose of having a constitution is to make this country cohesively, culturally, strong. Therefore, a constitution is required to be read by each and everyone. And today, whatever we are talking, whatever you are seeing, even whether it is might be a religious freedom, or you want a uniform civil code, or you want, socially and economically disabled, oppressed classes, whatever we are trying to find solutions to them, there is a cultural aspect in it. And that's what is important for each and every one of us to think about. And we have been, the Department of Law has been really doing well. I become a student of law now. Having completed my law degree, and after becoming Vice Chancellor, now I am picking up more and more jargons, large jargons, and also the finer points of what people were doing either in the court. And myself, I've been in the court for so many years, for 25 years, fighting my own cases, along with our senior counsels. And I know how it happens in the court, whether it is a lower court, high court, or a Supreme Court. And thank you very much, sir, for being with us today. And now I think we'll get some interesting questions. And those, when you answer those questions, I think I'll be more enlightened by your answers. Thank you very much, sir, again for being with us today. And thank you, Law College and all its faculty, Sudesh, Suresh, Dashrath, Satish, Jyoti, and Chandrakanti. All these 6 teachers. I've been carrying it for, instead of 4 pillars, there are 6 pillars. I think it should become stronger. And thank you very much.
Thank you very much, sir, for your valuable remarks. Thank you very much.
Thank you, sir. Sir, Vikramjith sir, with your permission, can we have a question answer session? Sir, with question, sir. What does the concept of constitutional morality stand when we read the Constitution culturally? Is cultural reading same as propagation of public morality as opposed to constitutional morality?
Can I answer that? I think that's a simple question. I've been speaking about it. If you read it culturally, the conception of constitutional morality different from social morality, different from public morality won't even arise. Then, as wonderfully put by the Vice Chancellor, is then everything could be interpreted cohesively. These issues are arising because you are not reading culture. You read it culture. Then these questions wouldn't be, there is no conflict. And as long as you read it culturally, there can be no conflict. The problem which arises and increasingly is arising is because and I'm not running anybody down. There are wonderful friends of mine, and I come from the National Law School, so I know who want to decontextualize the Constitution, who want to transform the people using the Constitution into something which they are not. Why do you use a transformative Constitution? And that's when you need constitutional morality, is the morality which exists within the Constitution, which is not public morality or social morality, which exists within the people. So that's when the conflict comes. If you read it culturally, absolutely no conflict.
Yes, sir.
Sir, I'll take over.
Let me see.
Sir, repeating the question, firstly, does the need to read the Constitution culturally arise due to the fact that much of the constitutional provisions were borrowed from other constitutions of the world? And because of this, the Indian Constitution appears uneasy and unfriendly with the cultural values of Indian people. This is by Dr. Jyoti Vishwanath, faculty member, University Law College.
I think it's a very simple answer, and that's why I contextualize it. That's what the first part of my presentation was, is that we had a huge civilization, but we wanted to create a modern state. And so that 100 years after 1857 to 1947, we should look at it as our way where we sort of fought for representative governance legally. Of course, about which eventually...
Sir, you're on mute.
Extremely important for us to understand in that context. We should not, it's extremely important that we there were a legal struggle to create the constitutional framework that we have today. And that's extremely important. So it's actually, in many ways, it's something which was fought over, debated over 100 years, or nearly 90 years when we formulated this. So the Constitution did not come completely out of context. Of course, it refers to everything in the world. That's one part of it. But there is a huge historical context for this Constitution.
So with your permission, one more question, sir.
Yeah.
What is the culture in the context of which Constitution should be interpreted? should it be the Western liberal values or some other value system? What value system should we aspire towards?
No, it has to be in terms of the Indic values, Indian civilizational values. I think that's the crux of my presentation. I think any constitution has to be interpreted in terms of the values which it is. I don't expect the American Constitution to be interpreted in terms of Indic values. It would be stupid of me to do that. And for example, two sort of constitutions which are very close to each other in some ways, the British and the American Constitution, completely different constitutions, completely different constitutional frameworks, because culturally, historically, are completely different. You know, the experiences of people are completely different. And leave alone us, what do we have in common with America, or for that matter, in Britain? Britain, yes, ours in some sort of, because they governed us for 200 years, but in America, nothing in common at all, unless one believes that history is lineal and we all want to end up being Americans. I don't want to end up being American. I don't know about the rest of the people.
Sir, this is where, sir, I would want to seize this opportunity. And on that note, I would want to pitch in a question here on the personal note, sir. So, sir, where does secularism actually stand in today's context? Because when we say secularism, there are two schools of thought which generally prevails. One is the Western school of thought, which borrows its idea from UK, France, and the United States of America. And then there is another school of thought, which is the socialistic school of thought. So in this conflict, sir, where does Indian secularism stand, and how should it be perceived?
See, you've seen that entire history, what I described. Indian secularism, the Supreme Court has said, is Sarva Dharma Samabhava, which is unique. Now, there are three ways to deal with it. Three ways, there are multiple ways. Every society, every constitution will deal with it in terms of the way it addresses religion in its own country. Now, let's not, it can only be read in context of its own society. America deals with it in a very, it has its historical context, so it deals with it in a Chinese wall between church and state. We know that. In terms of France, it says that you cannot have any public display of any religious symbol at all, called laissez-faire. And in terms of England, it is still, the Anglican Church still has representatives in the House of Lords. The King of England is still the defender of the faith. No, and I'm not saying it's unusual. I'm not saying it is just arises from the context of the historical context of England, of Britain, of United Kingdom. We cannot replicate their experiences to us and our experiences to them. We can only replicate it, or have some sort of to that maybe of 100 years which overlapped, or 200 years which overlapped. And we borrowed whatever, because 200 years is a substantial amount of time. So there was both give and take. There were things which happened there. We influenced them, they influenced us. So there was only that small, maybe more give, more take one side, maybe more take from us, possible. But that is all.
Sure, sir. So
With the permission of the host, may I ask a question?
Yes, sir.
Gautam Chandria.
Yes, sir.
Sir, with due respect,
yes, sir.
The way now you are bringing in new concept of reading the constitution,
yes, sir,
through cultural way, and bringing in dharma, artha, kama in constitution.
Yes,
to me, it looks like it is beyond the concept of nation state concept and beyond the concept of constitutional democracy. Somewhere, I think we are going retrograde, and we want to read this from Vedic angle. Something
so can I
new things and unsettling the settled things.
So can I answer the question? I think it's very simple. As I said again, this constitution has to be interpreted in terms of its culture. As I took you through, there are provisions in the constitution which talk about civilizational values, including Bharat, but whenever we talk about those civilizational values, we say they are Gandhian values, but they are there in the constitution. I am only saying this, that we need to read the constitution contextualizing it in terms of our own culture and civilizational values. From the time of independence till 70 years after this, we have been influenced by, better or for worse, and I'm not passing any value judgment on it, better or for worse, deeply influenced by a westernized interpretation of our constitution, our values. My only submission in this talk is that we need to, going forth from today, going forth from increasingly, and we'll face this challenge increasingly, is that it is time also that we interpret it in context of our civilization and our own culture. Whether we can call it Gandhian values, whether we call it dharma, artha, kama, whichever way we call it. I suggested dharma, artha, kama. If we are allergic to that, then it's fine. You can take it and call it Gandhian values. But these are values which are incorporated in the constitution. These are values which are not liberal values, or liberal values have as much weight in DPSPs as Gandhian values. Why are we today disregarding that? If it's the term, as I said, one of the contradictions of the Indian constitutional interpretation is this, that we do something which is akin to our civilizational values, but we say something else. We use liberal logic, we use Western rhetoric, languages, words to do Indian things. And I am only saying, call a spade a spade. Call it for what it is. It will be easier. It will lead to less problems. For example, something like Sabrimala. And this problem you're going to face increasingly, because the increasing distance we are going to get from our former rulers. Today is 70 years, 30 years later it is going to be 100 years. The more distant the memory of Western civilization having been ruled over us, we'll have to rely on ourselves.
Difficult, sir, very difficult interpretation. I think this may lead to disintegration of the nation. Thank you, because several cultural, several interpretations. Thank you, thank you.
So one more question, sir, if you're open.
Yes.
Sir, do you think the words custom or usage in definition of law found in Article 13, Clause 3 often been neglected in the pursuit of attempting to interpret the Constitution in cultural sense?
I didn't get what was saying, but I guess that customs and usages should also be used to interpret the Constitution. But it's interestingly, and as I say, the Constitution is a culmination of us. And that's why I say it's important to contextualize and to say that the Constitution is not alien to us. It's because the Constitution was also a struggle to create a modern state out of a civilization. So we believe when we formulated the Constitution, people should have equal rights. Women should have equal rights. You can't discriminate based on jati. So to that extent, the Constitution also believed that custom can be a basis of discrimination. Custom can violate fundamental rights. So it made customs also subject to these provisions in the Constitution that we incorporated. Because as I said, make no mistake, and I'm a Vivekanandite in that respect, where I believe that you have to test everything on reason. Make no mistake that we wanted to create a modern state. There should be no doubt about that. There was no going back to the past, because we'd seen the past, and everything about the past is not wonderful. So we wanted to create a modern state. So we created a modern state. We said all this, we will keep what has been great in our past, but we will have to test it in terms of modernity, in terms of rationality, in terms of what is good for our people. And the Constitution, I think, creates or tries to create that balance of keeping the past while bringing in modernity. And this is the struggle for 100 years. That's what I said. You not only look at it in terms of independence, but look at it as form of representation. You have to look at the Pune Pact for what it is.
So last question, if I may, sir.
Yeah.
This person has been spamming the chat box for some time now, so I'd better.
Not an issue.
So, sir, do you think that, so this is kind of a futuristic question as well, sir. So, do you think that our secularistic and socialistic nature of the constitution would prevail in the long run? If at all there's a transition, how would it be?
No, I don't think, see, as I said, words are what you make out of it. What is the spirit? It's the same thing. When you call secularism Sarva Dharma Samabhav in Ekam Sat Viprabahuda Sadan Badanti, and when you talk about socialism being Sarvodaya, you made it out anyway to be completely different. It is like as if Western jurisprudence, you are governing in, as I said, Supreme Court also has been governing and conceptualizing governance in terms of Indic principles. But it has been using Western rhetoric and Western language to justify it, to make it acceptable. While my feeling is it shouldn't matter. And this is not my view only, and I must acknowledge this. My guru is Professor Mensky, whom you may have heard of Varna Mensky of School of Oriental African Studies, where I worked with him in my dissertation project, and we had this discussion at one point of time. So he said, why does this happen? He says the more Indian courts use Indian civilizational remedies to solve any Indian problem, the more it uses Western language. He said, this is unique. This has never happened in anywhere in the world. So you will solve it in how exactly it is solved in India. But you will use in terms of Western jurisprudence, which is you have to twist it to fit into that issue. While a shorthand would be, why don't you call Sarva Dharma Samabhav instead of secular Sarva Dharma Samabhav? That's actually what you mean. And the fact that tolerance of different types of faith is not unique in Indian civilization. I can take you back to even Ashok, or even before that. That's a tenet of every state which we've had. Even times of the Guptas, it's not like the king treated all faiths equally or in a similar way. The state knew what its civilizational background was, but it treated all faiths equally. That is the nature of our civilization. This is not unique. Supreme Court has said it's not unique, but it has to use the word secularism. It's this touchstone of using Western jurisprudence as a method of justifying Indian governance. I think 100 years, nearly going to 100 years after starting to rule ourselves, it's time.
Thank you very much, sir. Kindly accept our Ganesh Chaturthi wishes to you and your family. With this,
thank you very much, Vikramjith ji. Thank you very much.
No.
Vinay, over to you.
Kindly pay attention, ladies and gentlemen. I now announce the next lecture, that is 12th lecture of the ULC Special Lecture Series with Miss Jaina Kothari. Director and co-founder of Center for Law and Policy Research, a legal research organization dedicated to the defense of constitutional values in India. She graduated from ULC with BL LLB degree and our own proud alumni. She had argued in the Supreme Court in the recent constitutional challenges to Section 377 of IPC and adultery, and has also argued in the independent thought case. Madam will be discussing regarding harassment of women on social media, which is the pressing problem and discussed topic in this digital world. I request all the participants to mark your calendars and join us on 24th August 2020 at 4 p.m.
So I think with this, we can conclude the session.
Yes.
Okay, thank you once again, Vikramjith ji, for sparing your valuable time and addressing all of us and answering all the questions.
Sir,
On behalf of
formal vote of thanks.
Chancellor and all our colleagues, I wholeheartedly thank you once again. Thank you very much, and we would like to
Thank you, Vikram Banerjee.
when the pandemic gets over. Thank you.
Thank you, Vikramjith Banerjee. I am Venugopal, Vice Chancellor, Bangalore University. I really liked your discussion and the way you answered those questions. really intriguing, but it is necessary that we have to see the constitution culturally. Otherwise, constitution will not remain.
Okay. Thank you. Thank you.
Now I come to the end of the session. The essence of all beautiful art is gratitude. Good evening, ladies and gentlemen. I, Vinayam, on behalf of University Law College and Department of Studies in Law, Bangalore University, consider it my pleasure to render the vote of thanks. Let me first of all start by giving glory to the Almighty God for making today's occasion a resounding success. I extend my heartfelt gratitude to Shri Vikramjith Banerjee, Advocate, Supreme Court of India, who shared their precious knowledge with all of us. Sir has given a very interesting and thought-provoking lecture. Despite his busy schedule, Sir took the time to deliver this special lecture in the ULC Special Lecture Series and wonderfully address the participants. It has been an ever-gathering great pleasure for everyone, sir. Thank you, sir. I would like to express my heartfelt gratitude to our patron for the event, Professor Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University, for gracing this event. His able guidance has always encouraged us. I thank Sir for his kindness, interest, and continued support in all our endeavors. Thank you, sir.
Thank
I
you.
would
Thank you
like
very
to
much. Thank you to all of you.
I would like to express my profound gratitude to Professor Dr. Suresh V. Nadagaudar, Honorable Principal, University Law College, Bangalore University, for his stewardship, support, vision, and commitment. Thank you, sir.
Thank you.
I would also like to thank Professor Dr. N. Dashrath, Honorable Chairman, Department of Studies in Law and Dean Faculty of Law, Bangalore University, for his moral support and guidance. I thank all the faculty members for this constant support and encouragement in all our efforts. I owe a special gratitude to the student organizing committee for their persistent efforts, determination, and dedication in making sure that this lecture was conducted without hitch, and congratulate them for the success of this event. I will also extend my heartfelt gratitude to all the students and participants in this lecture series for turning up in such huge numbers and making this event a grand success. Thank you, one and all.
Okay. Thank you. I thank Sri Gautam Chandji, who is the president of our alumni association, and
Thank you.
Sri Yampe Gowda, who is the principal of Law College, and also Sri Ramkrishna sir for joining us today. Thank you very much.
Thank you. So I'll join the next lecture on 24th.
Please, sir. Thank you very much. Thank you.
Okay. Namaste.
Thank you, sir.